0182-SCR, Bryan Anthony Valdez versus the state of Texas, Mr. Spriggs, representing the appellant, correct?
Yes, Your Honor.
Okay, very good. And Mr. Clark,
Yes, Your Honor.
representing the state of Texas.
Yes.
Now, you're doing the entire argument, and you're gonna tag team, you're gonna make your colleague there answer the hard questions.
Well, he's here for morals.
Okay. Okay.
But I'll be conducting the response for the state.
I know that you've appeared next to him for moral support in other arguments, so.
I was going to put it another way. Thank you for supporting his morals.
We will not go there. Thank you very much. Mr. Spriggs? Yeah.
Council?
Yes, sir.
Council?
Before we start, how's your father?
Can we take it up some other time, Your Honor?
Okay.
It's
Okay, no, that's
a
fine.
doozy.
That's fine. Okay. I apologize for.
No worries.
Okay.
Justices, I think what we're looking at is an intersection of choice of counsel and consent to counsel. Choice of counsel, we know it's constitutional. We know that the Constitution in the state, the federal Constitution, state Constitution, both require us to afford a defendant his choice of counsel with limitations, reasonable limitations. He can't use it as a dilatory tactic. We're looking at it as an intersection recognized in Feretta, recognized most recently McCoy out of the US Supreme Court, is where choice intersects with consent. Will defendants start dressing up choice of counsel as consent to counsel, saying this criminal defense attorney, here an appointed defense attorney, did this guy, can I just say I didn't consent to him instead of say I don't choose him and I'm out of it? I get what I want.
Let me ask you this. In your view, what did your client want?
I can't speak to his state of mind at the time. I can speak to the record.
Okay. I guess maybe the better question is what are you arguing to us as the purported violation, that he was not able to select his own appointed counsel, that he wanted to proceed without counsel, or something else?
I think he wanted all of the above. I think he was taking a shotgun approach, but in his shotgun approach, he did assert some legitimate rights that have to be recognized. He did say, I want counsel of my choice to be appointed. He can't get there.
Okay.
Doesn't work. But he also said, I don't consent to T.D. Hammonds. T.D. Hammonds didn't call me. And I'm not beating up on T.D. This is just on the record. I met T.D. I know him from the criminal defense, the PCDLA local defense bar. The T.D. Hammonds didn't contact him until the day of or the day before, a few hours. What's more is after there was the delay in the case, it was originally set before Judge Board, and there was delay of about a month, a couple of weeks at least. There was nothing in that delay to cure that lack of communication between defense counsel and defendant. In that lack of, in that apparent absence of communication to cure that original non-communication that had upset Mr. Valdez, there's nothing to show. Judge, I talked to his witnesses. Judge, I consulted with him about his defense strategy. Judge, I talked to him about whether he wants to testify. Some pretty basic investigatory Strickland standards and some basic fundamental rights, particularly with the right to testify. This was a revocation hearing. At revocation hearings, the standard is pretty low. They only got to prove one out of however many.
So is he saying his counsel is not providing him reasonably effective assistance? Is that the nature?
No,
of his
that is separate, but it could be triggered. I don't think it's triggered in this case, because in my reading of the transcript and my reading of the judgment, TD did a fair job. I know Mr. Valdez, I think he wanted not to get revoked. So I think his standard is different than TD's, but as criminal defense counsel myself, getting 2 years out of 10 ain't bad. It wasn't TD that got him the 8. The judge, okay, the prosecutor suggested 2 years. TD worked to get as low as a sentence as he could. It was the judge, and I'm not blaming the judge, but this is the judge's reasoning on the record. She says this defendant isn't taking responsibility for his action. In essence, I'm not quoting verbatim, and she departed upwards from the state's recommendation. So as to TD's specific performance under Strickland, not making that claim. I don't think it gets there.
I want to go back to your first argument, the choice versus consent.
Yeah.
So let's follow that. Where should the line be as far as when they don't get to say, I don't consent anymore? So for example, if I don't consent to TD Hammonds, okay, I get you another one. I don't consent to Mr. Spriggs, whoever it is. How many do they get? Or where should the line be?
It's not a, forgive me, it's not a line. It's a matter of looking at how specific we're looking at. We're talking about the general idea of a particular counsel. I don't like A, I don't like B, I don't like C. That's a choice. We're talking about consent. We're looking at fundamental individual decisions. Whether I want to testify. Yeah, consent to whether I want to plead. If the defense counsel is saying, we're going to plead you, I think it was one of the Supreme Court decisions, we're going to plead you so you avoid the death penalty. He's still happy with his choice of counsel. He's not complaining at that moment in his choice of counsel. Instead, he's saying, this counsel is not assisting me anymore. I don't consent to this defense. I don't consent to this defense counsel because he's not doing the job I want. It's not so much a global choice of counsel anymore. It's where the case is being directed.
So he's not consenting to that attorney, or he's not consenting to the attorney's strategy?
For the defendant, it's for the pro se, for any litigant,
For your
any layman, for any layman litigant.
Now, for your client,
For my guy, it's once you answer the question, I don't consent to this particular strategy, you also answer the question, I don't consent to this particular attorney, particularly when you're talking about basic fundamental rights. If you were to say,
where does the record show that he did not expressly show he did not consent to the strategy? Or
not in his words, Mr. Valdez in arguing the court and speaking to the court, he's not going to present anything that sounds like that, registers like that to us. What he did say is he hasn't talked to me. I'm not sure if there was any mention on the record, but discussions about witnesses, discussions about where he wanted to go, ultimately with his choice. My reading of the record suggests to me that Mr. Valdez wanted to ultimately contest everything, not just the basis for the motions revoked, but the judgment itself. I think it's a bad decision, but it's his decision. I think he would have lost.
Now, he's not entitled to what I would call hybrid representation. He can't be pro se and also have an attorney, right? But essentially, that's what you're arguing. He wants to do all the strategy himself, but also have an attorney there.
No, in the brief, what I'm suggesting is that instead of hybrid representation, when he tells the judge, I don't consent to Mr. Hammonds, the judge, trial judge should have said, well, these are your forever warnings. Instead of asking Mr. Valdez, do you understand this? Do you understand this? Do you understand you're a layperson and we're going to hold you to the same standard? The judge should have said, these are the forever standards. You're going to be held to the same standard an attorney, period. Tell TD Hammonds to set aside if he wants to invoke his right to counsel, but otherwise, Mr. Valdez would be proceeding pro se. There was a solution available there that day. It's just to say, okay, Mr. Hammonds either leave and Mr. Valdez proceed pro se.
But how is the trial court supposed to proceed under this scenario when he eventually says, oh, I do want counsel, just not this one? Is she still to
No.
say, I've already given your forever warnings, we're going?
No,
pro se?
that's, yeah, you're respectfully, that's already been covered several times. If he says, I want counsel, but I don't want this one, the judge, trial judge, there's trial on it. There's case on it. That judge says, this is your attorney, period. You've invoked it. You've waived your, essentially, you've waived your right to waive counsel at this point.
Your choice at that point is you stick with this lawyer
Yeah,
who
he
was
can't give
appointed,
it-
or you go by yourself.
Yeah, he can't be inconsistent. Once he says, okay, once he originally invokes his right to pro se, to present his case pro se, he's allowed to. The second he says, I want an attorney, The court is allowed to give him an attorney, and he's stuck with that attorney. He's not allowed to shift from yes, I do, no, I don't, yes, I do.
But the moment he says, I'm not satisfied with this attorney, he didn't get to pick another one. He gets a Feretta hearing on whether he's gonna do it by himself.
Separate question. He can say in the middle of the hearing, he is the client in control of his case, can supersede his attorney, say, you're not doing what I'm telling you to do. You're not taking this case in the direction I think it should go. I'm dismissing you. He's allowed to do that. But at that point, he's not allowed to come back and say, give me another one. I
Right.
want you back. He's allowed to say in the middle of the proceedings, 3/4, 5/8, however far into it, to say, I want to go pro se. That's his business.
That is subject to, though, the court making sure that it's a knowing voluntary waiver of his right.
Yeah, instead of asking questions about Feretta, the Feretta admonishments, you just admonish him. This is the same way you would admonish him before a plea. You tell him, you give him a statement, give it to him in writing, let him go. Here, I think the issue is they wanted to question him on it. Do you understand? They want, instead of, let me talk around it and I'll give you an illustration. For the Miranda warnings, instead of at the time of arrest asking, do you understand you're under arrest? Do you understand you have a right to an attorney? It's, you are under arrest. You do have a right to an attorney. Anything you say. Here, it should have been the same thing at that first hearing. Instead of saying, do you understand this is difficult? Do you understand you'll be held to the same standard? It should have been a statement, clear statements, clear affirmative statements, possibly in writing. This is difficult. You will be held to the standard of an attorney. It will affect your ability to appeal. I think those Feretta standards, I think the trial court made the mistake of saying, we need to give these to him as in the form of a question.
If we adopt your position, how does a trial court ensure that it's a knowing and voluntary waiver? Other than I've read the list and you can, and what, you're on your own at that point?
Yeah,
Or
it's
what?
it's across the board asking the defendant to do something knowingly and voluntarily. You never really know if they know. You never know if they're intelligent. Intelligent compared to what?
Well, I'll expose to you, I've got a case right now where the Feretta warnings are being challenged for their specificity because the claim is that the judge did not ask specific enough questions. And so
My reading of the case law is that it has to be just enough. It doesn't have to be perfect. He doesn't need to be as intelligent as an attorney. He doesn't need to be as intelligent as a college graduate. It's just enough to say, hey, we're giving you fair warning. You do this, you're stuck with it.
Do you have to give the Feretta warnings when the accused wants counsel?
You have to give it. At what stage?
Any stage. I want an appointed attorney. Does the court have to give him Feretta warnings?
No, Your
Or
Honor.
does Feretta warnings, the Feretta warnings are triggered when the accused wants to represent himself?
Yes, Your Honor.
Okay. Go back to Justice Yarborough's question. Did the court have to give Feretta warnings here, even attempt to give Feretta warnings when Mr. Valdez said, I want an attorney?
Yes, Your Honor.
Why? Because if he wants, Feretta warnings are for the purpose of assuring that the client knows what he's getting into
He was,
by representing himself.
yes, Your Honor.
But he doesn't want to represent himself. So why do you have to give the warnings?
Because he was trying to do two things. When I said he was doing that shotgun approach, he was doing two things at that first hearing. He said, I don't consent to TD Hammonds. Means you got me a court-appointed attorney, but I don't want this one. Means the court should have proceeded to the hearing, given his Feretta warning, say, okay, we appoint you to an attorney, you don't want this
But
attorney?
is it a choice? You take this attorney or none?
Yes,
Or, and we've written on this, we've abated when an accused contends that his attorney's denying him effective assistance of counsel. We've abated to the trial court to determine whether or not that's true, and if it is, appoint another attorney. So it's not this or that.
you're right. Here's where my previous answer, my yes, was incorrect. There are three possibilities that are discussed. Grant him his new attorney, deny him his new attorney, or I think the last one addresses whether or not it's the dilatory tactic. Ultimately, what the trial court is looking to do, in my opinion, is to avoid that dilatory tactic because it can be repeated ad nauseum. If as in here, Mr. Valdez says both things, I don't want this attorney, but I want my own choice of attorney. And there's already been an attorney appointed. The court has a couple of options. It can say, we'll allow you this delay. We'll remove T.D. Hammonds and we'll appoint you an attorney, but not of your choice. Maybe the court wants to do that, maybe it doesn't. It doesn't have to. It's my guess. The court has discretion in that. Or the court can say, you can't get it both ways. You fired T.D. Hammonds. We're ready to go. The state has an interest in pushing this case through and getting this case through, clearing the docket. We're going to go today. You fired T.D. Here's your further warnings. It's when he's there without an attorney at his own request, or he's fired his either hired or appointed attorney, that he's looking as Ferretta, that those Ferretta admonishments are triggered.
Okay, but let me extend from what you're saying, I guess. My understanding from what you're saying is rather than having Ferretta warnings that are done in question and answer format of requiring the defendant to acknowledge certain things, I understand that I may get a more harsh sentence. I may understand, I understand that I can't represent myself as well as an attorney or those questions. There's another phase in the trial process when we provide admonishments and have to get a knowing and involuntary consent. And that's when the defendant decides to testify. Those are certainly done in question and answer format. And we have said under those circumstances, if a defendant voluntarily decides to take the stand to testify, the court is proper in asking them in question and answer form. Why don't we require the same standard here?
It's just the way the analysis has come out under different rights. Here we're talking about the right to counsel. That's the right to testify against, not testify against oneself.
So he has the right to remain silent, so court can't ask him questions because he doesn't have to testify?
I'm sorry?
I'm trying to figure out what you just said.
Doesn't that play the Fifth Amendment right and the Sixth Amendment right against each other?
No, not at
That's
all.
to say you've got to have, you don't have a knowing and voluntary waiver unless you ask these questions for a Fifth Amendment waiver of self-incrimination. But on the other hand, you don't have to do those things when we're involving Sixth Amendment right?
No, not at all. The analysis for each right has different lineages. The analysis for the right to counsel comes down a different path than the right to testify against oneself. That's just the way the case law developed. Somewhere in the right to testify against oneself, they said, you can ask them these questions, and that's where that's at. We don't have that issue. That's not in front of us. In this issue, in the lineage of the case law as it developed, it said, you're going to give these Ferretta admonishments. It doesn't say they have to be questions.
Does it say they can't be questions?
No, they're not. They can ask questions if they want. It's probably not a good idea, but they can ask questions.
What do we do under circumstances when somebody refuses to answer the questions?
As in this, with like on these facts or in any other
Right.
facts?
Let's say these facts.
On these facts, if he refuses to answer the questions, you hand them to him in writing, or you just read them. You just read them. These are your Ferretta warnings that you're going to be held as we've gone through the list. You're going to proceed pro se. Either Mr. Hammonds is there if you invoke your right to counsel, or Mr. Hammonds is there, but you're going to be stuck with him for the end of trial. If you don't, you're held to the same standard.
Haven't courts in a situation where the party wants to represent themselves, say, okay, we provide the Ferretta warnings. You've made your choice. It's a knowingly and voluntarily made waiver of your right to attorney, but we're still gonna have counsel X as backup counsel just in case, stand by.
I missed the question, Your Honor. I'm sorry.
Can't the court do that?
Yeah, that's
So
frequently
it's not a
done.
situation where where the court has to say, you don't get any attorney, or you gotta get this one. There's leeway, right?
And I guess if you've got backup counsel, you don't
he's
necessarily get Ferretta warnings then.
No, he still gets Ferretta warnings. When the counsel sits down and says he's on backup, he gets those Ferretta warnings because he's proceeding pro se. As to your question, I don't know if they're doing it right or doing it wrong at this point, but it's my experience that that's frequently happens. Somebody says, I don't want court-appointed attorney. Court is intent on proceeding that day. Court-appointed attorney is saying, okay, Mr. Defense Counsel, take a seat in the back. You're not going to participate unless you're asked to. If he's asked to, the defendant is at that point waived his right to appear pro se, and he's now appearing to that counsel. And yes, he's stuck with that counsel, even though he said, I didn't consent to this guy, I didn't choose this guy, I don't like this guy. He looks at me funny.
So what's your prayer for relief? We remand this back for the proceedings and they start over and he gets a choice to consent or not to the court-appointed attorney?
That he gets, essentially, yeah, he gets remanded. And he gets his consent to counsel. Or he
His
can go,
choice.
or he goes, well, it works out to be his choice because that's the way you get
But we know
consent.
that you don't have a right to that.
Well, that's where we begin. Where are we conflating consent and choice? If there's no consent, there'd never be
Justice Scarborough's
choice.
original question is how far do you go when you say I don't consent, don't consent? Doesn't that get to a point where you're actually saying I have a right to choose my own counsel because I can continue to consent?
Yeah, it can't, well, no, because you're looking at the details. Is the defendant presenting something there as far as a basic fundamental right? Or is it just a global objection to counsel? Meaning, is there anything developed on the record as to specify this choice? Is it a strategic issue? Is it a basic rights issue? Or is it, I don't like this guy?
Counsel, your time's expired.
Thank you.
Thank you very much. You do have 5-minute rebuttal.
May it please the court, Mr. Chief Justice. Allow me, if you would, to present what the state submits really is the issue as stated in the appellant's brief. I've read through it very carefully. There's some various threads, but I think it boils down to this question as contained in the appellant's brief. Does the Sixth Amendment right to counsel oblige, and that's the verb, the operative verb used in the brief, oblige a defendant to consent to appointed counsel? The state would submit that the real issue, when you boil it down to what happened at the hearing, is was it an abuse of discretion for the trial court to compel the appellant to accept the services of the court-appointed attorney, even though he didn't want it, in order to proceed on to the hearing on the motion to revoke? Now, the answer that we submit is a very clear no, that was not an abuse of discretion.
The way you cast that question, are you saying he didn't want any attorney or didn't want that attorney?
Okay, let me in order to answer your question, let me repeat what my stance again is that the question is, given the circumstances that existed at that time and given the history of what happened leading up to the day of revocation, was it an abuse of discretion for the trial court to say, no, I'm going to deny your third request for your personal attorney that you approve of, and you're going with the attorney that's been appointed on your case, that attorney, we're going forward.
That's a little different than the first way you said it. Okay, now I understand.
Was that an abuse of discretion? No, it was not. Now, it sounds harsh that we're compelling defendants to undergo these hearings with attorneys that they don't approve of. But sometimes, and I know this may sound a little off the wall, but the law has to do things for the benefit of the defendant, even in spite of him, even when he opposes this. And let me run with that for just a minute. The brief has referred you to the Burgess case, and the Burgess case is important because it sets the conditions under which this compulsion is approved. And we know that in the Burgess case, it holds the following, that when a defendant seeks a last-minute change of counsel, there's no doubt this is exactly what it was. when he does not waive counsel, under no circumstances does this record support the proposition that he wanted to waive counsel. When he did not assert a right to self-representation. I've listened to this Ferretta discussion. Ferretta has nothing to do with this case. He did not want to represent himself. When he is asked to articulate the reasons why he wants the removal of counsel and substitution of counsel, and those reasons are clearly insufficient, and he has been given more than adequate time to secure counsel of his own, the trial court may compel the defendant to proceed to trial with the attorney in place, ready to go. That's Burgess. I went back and read Burgess, and so did my colleague. And my colleague found a case that I didn't know about. I'm grateful that he brought this to me. I read it.
So it's more than moral support.
Sir?
It's more than moral support. He's actually teaching the law.
He is, and he did. The case he provided, I want the court to mark this down if you would review the case after argument. It is Oliver versus State, 872 Southwest 2nd, 713, 1994, Court of Criminal Appeals. Now, in this case, they addressed the conditions under which counsel may be forfeited. The case came out of Harris County. It was a big mess, but they talked about how does forfeiture occur? And they held in a ruling that still stands that the failure to request counsel will never be considered as a forfeiture because of the implementation of counsel is so fundamental and such a part of bedrock jurisprudence that the mere failure to request counsel will never be considered forfeiture. And this involved an arraignment stage where the defendants didn't specifically request counsel. The state tried to sell the court on the proposition that, well, they didn't request it. The Court of Criminal Appeals held, no, that's not the test. The right to counsel will never be forfeited by failure to request its implementation. And in that opinion, if you read it, it's not very lengthy. It has some very interesting language that has direct application to this case. They opine and observe that the fact the courts must appoint counsel to indigent defendants does not mean that criminal charges may be litigated without the express or implied permission of defendants unrepresented by counsel. The opinion went further and observed counsel will not be appointed to a defendant unless he wishes it. We can't force a lawyer on him. They recognize the autonomy of a defendant. Just because he qualifies for appointed counsel doesn't mean that he has to accept it. So in the record, when the defendant makes the statement, hey, I never asked for T.D. Hammond. They just appointed me on him. You know, he's made a point. He's correct about that. Well, what happens, Judge Yarborough, if the following comes about? You have a defendant that does not wish appointed counsel because he doesn't approve of him. He has been given time to hire counsel and he didn't. He does not waive his right to counsel. He certainly doesn't want to represent himself. And he announces, I want my own lawyer for the third time. And he says, I'm not ready for trial and everybody else is. What does the trial court do? Well, Oliver provides the answer. In the Oliver opinion, it states the following: failing either relinquishment of the right, that would be just I'll represent myself, or here's the key term, abandonment of the right to counsel. A judge may not conduct any adversary proceeding until the accused is represented by counsel. So you have a situation where the court has an option. Burgess talks about it. Oliver focuses it much better. In other words, counsel at the side of the accused, whether the accused desires it or not, is required until and unless the accused abandons that right.
I understand that you're saying Oliver and Burgess say he's required to have an attorney, even forced upon him if he doesn't want one. Setting that aside, in this scenario, is the Sixth Amendment actually fulfilled though? If on the record, we show the defendant lacks confidence in this attorney that's been forced upon him.
It doesn't matter whether he lacks confidence, because let's consider what happened on this record, and then I can expand further on your inquiry. In this record, the judge took the time before the actual revocation hearing to ask the appellant, tell me what your complaints are about this lawyer. If you read the record, his complaints as a matter of law do not constitute good cause. It's simply a personality conflict, a complaint about a particular service. And the judge said, is that all? Is that all you have? And he said, yes. That in and of itself, what are we asking the judge to do, Judge? We've reached a point where the determination is he doesn't want to represent himself. He doesn't like his appointed lawyer. He's been given time to hire a lawyer. His reasons about his appointed lawyer, his complaints are insufficient as a matter of law. The Burgess case says you may compel the defendant to go forward. And all the Oliver case is important because it states that unless he's relinquished or abandoned, then the lawyer in place must be there before the defendant faces an adversary hearing. He cannot go into that adversary hearing without the guiding hand of counsel. The system will not tolerate that. Now, what did the judge have as an option? It could consider, well, I'm going to go forward with this hearing and your lawyer is in place and he's prepared to go. Or I can find that you've abandoned your right to a lawyer and we will proceed. And I suggest and submit that the latter suggestion is intolerable, to have a man go into litigation with the state, considering all of our resources, without the services of a lawyer.
Is there a third option where T.D. Hammonds could be a standby counsel?
It could. The judge could have done that. However, the judge elected to proceed with the hearing with the defendant being guaranteed the guiding hand of counsel. That ensures and it adheres to the Sixth Amendment. You know, the Sixth Amendment was scrupulously honored throughout the course of this case. And it's interesting that counsel for appellant, maybe he didn't realize it, but he really did state the purpose and intent of the appellant. Not only did he not approve of counsel, he didn't approve of the whole process. He wanted to challenge the judgment. He wanted to challenge everything. He had that opportunity when he was convicted, and for some reason, the jury gave him probation. He did not appeal that finding of guilt. So I think you get a little look into the thinking of the defendant. His behavior was a pattern of obstinacy to prevent the eventual hearing and the evidence that came forward. He certainly didn't help himself on the stand, but nevertheless, the appellant does not complain about the sentence or any other process attendant to the hearing whatsoever. And we now have a concession from appellant that his counsel did a good job. And he did. He got him a 20% discount. on a 10-year maximum sentence. We would simply submit that established case law holds that the course that the trial court took in this case was eminently reasonable and certainly not an abuse of discretion. And any entertainment that the defendant holds some sort of ability to impose consent on a trial court to move its docket, to me, is equally as intolerable as forcing him to go through a hearing without a lawyer.
Thank you, counsel. Wilson?
Yes, Your Honor. You know, briefing this case, getting this case ready, case I really thought you guys would want to talk about is McCoy. McCoy's 2018 decision of the Supreme Court. I thought you guys would want to talk about that one because
Do you have a site for that?
McCoy? Yeah. You bear with me for a second?
Sure.
I've got it. 584 US 414.
Yeah, 2018.
2018 case.
McCoy v. Louisiana. That's the question. It's not the first time it's come up. It's come up a couple times. Defense counsel goes out and says, I'm going to do this instead of what my client wants, because what my client wants is going to get him killed. There's another case out there. It was the guy's essentially dead to rights. He committed a murder, gets caught. He wants to plead not guilty. His defense attorney says, you plead not guilty, they will kill you. You will get the death penalty. Well, goes up on appeal. The appellate court says, yeah, he gets to do that. That's his choice. You are the assistant. The right acknowledged and codified, the right in our Sixth Amendment is the right to assistance of counsel. This paternalism that the state is describing, that does not fly. What flies is the defendant, right or wrong, educated or uneducated, intelligent or not intelligent, he gets to make the fundamental question, the calls, decisions about his case. Counsel is there as an assistant. Now we're listening to the state. He gets to be obstinate. The defendant gets to be obstinate. He gets to say, I don't like the judgment. I want to complain about it. That's why we have a writ process. He gets to fight that judgment until it becomes moot or until he passes away. That's his right. That's the law. He didn't abandon his right to an attorney. The way it works is you invoke your right to proceed pro se. When a person has invoked the right to proceed pro se, they can always, if they haven't already messed it up, they can always say, Judge, I'm messing up. I don't know what I'm doing. Will you please appoint me counsel? In this case, if T.D. Hammond is in the back, he can say, Mr. Hammond, you're going to take over, but Mr. Valdez, you're now stuck with him. You waived, not abandoned, you waived your right to proceed pro se from this point further because the court has an interest in the efficient disposal of this case, the efficient disposition of this case. I'm sorry.
You agree with the state's position that that right to counsel is self-executing. You are a defendant. You have a right to counsel. You don't have to ask for that right to counsel. That counsel is appointed to you, and that your process is to then ask the court to undo that appointment versus not having counsel unless you invoke it. The defendant doesn't have to have magic words to get an attorney.
No, he doesn't have magic words to get an attorney, but I think it varies jurisdiction, even within Texas, whether or not a defendant has to appear and request counsel. He has to, if he can't afford a counsel, the jurisdictions are going to have him fill out a sheet to say whether or not he can actually afford or not afford. In that essence, he's asking because he's doing the sheet. He's telling him his financials. The whole process is saying, I want an attorney. I need an attorney. I can't afford an attorney. By going through the process, he's inherently, if not explicitly, at least impliedly saying, I need an attorney. Please get me an attorney.
Did your guy do that here?
No, he didn't. Matter of fact, I'm glad you asked. If we could go back, and we don't have time now, if I could get you, when you're reviewing this case, go back, look at the record. He, in fact, Mr. Valdez said, it did in fact say he wanted to go by himself. He wanted to proceed pro se. There were two hearings, one under Judge Board, the other, Judge Board sitting as visiting judge, and the other under Judge D. Johnson. At the last one, he said, I'm gonna go pro se. Board, I think, is the one who tried to initially admonish him on his FRED warnings when he dismissed T.D. Hammonds. But Honorable Board decided, John Board decided to do it in the form of question. Mr. Valdez again was obstinate, and that resulted in the case being delayed. Your Honors, thank you very much.
Counsel. The case is submitted and you are excused to go, and we will be in recess for a panel change. Thank you very much.